maybe you're better off, drip feeding them income to support their lifestyle rather than giving them access to, hundreds of thousands of dollars, because that will make things worse. So I really like the idea around testamentary trusts and shaping it like that. I guess the complexity is always trying to anticipate, what's going to happen tomorrow when you're here today.
Yeah.
Because things do change.
Welcome to 360 Money Matters, where financial planners Billy and Andrew talk all things financial planning. This podcast aims to increase your knowledge and confidence with all things money. Each week, they will cover topics such as investing, cash flow, budgeting, saving, passive income, debt management, and much more, so you can live a life on your terms without limits.
Hello and welcome back to another episode of the 360 Money Matters podcast. I'm Billy and I'm joined by my co-host,
Andrew. Bills, how are we? We're back again for another 360 podcast.
Andrew back again for another 360 Money Matters podcast, and talking to our viewers and our listeners today about the enthralling topic of estate planning.
Yes, absolutely.
It may be traditionally in the past something that you do put in the bottom drawer and forget about, but we're going to do a deeper dive to try and bring, I guess, a few of the things that we think about when we're talking to clients about it, what it looks like, what you should consider, some of the complexities, and why you should get advice, because it is such a complex area.
Yeah, absolutely. And the implications of it are just so huge. So, yeah, I mean, look, a lot of people think about estate planning and all you're thinking about is, okay, who do I want to have my money when, touch wood, I pass away? But I think there's a little bit more to it than that, and a few more considerations that you might want to make when you're talking about this.
Just a little bit. You're right. That's probably the biggest misconception that people have, is just who gets my stuff, and that's the extent of it. But Andrew, let's kick off. What's the first thing that we want to get across to everybody today?
Well, the first thing is the thing that everyone thinks about, right? I mean, the first thing is, who do you actually want to receive your money? And that can be, whoever you like when you're talking about estate planning, whether that's a friend or a neighbor or someone that you've got a very close relationship with, or whether that's kids, parents, spouse, whoever it is. It's actually documenting what your wishes are and who you want to receive the proceeds of your estate when and if, touch wood, something does happen to you.
Yeah, and I think documenting it, we've all heard different stories in the media and stuff, but doing that in the right way with a professional, they can assist, they can judge whether or not, well, not necessarily whether or not, but by using and engaging with a professional, the chances of making a valid will versus doing it yourself and it being invalid, that's probably what you're paying for.
Yeah.
Along with the advice that you will receive as well. So making sure that your will, when you do it, is valid, because there's some legal complexities associated with, is it just a piece of paper, and does it actually mean anything, and is it enforceable?
Yeah, absolutely. And then the second thing is, which I think most people just stop at step one, but step two is how do you actually want your beneficiaries to receive the proceeds? So most people think about it and you say, okay, I want someone to receive $500,000, off XYZ asset. And that's kind of the extent that you think about it. And that can be perfectly fine for the majority of situations, and that person will do what they wish with either those funds or that asset. But there are many instances where you may not want to give someone a lump sum amount of money. So whether there is a beneficiary that is disabled and can't actually manage money on their own, whether there is a beneficiary that has a substance or an addiction problem where they can't actually manage that amount of money, and that's probably not going to better their situation by leaving them a lump sum amount of money, and only going to worsen.
Actually.
Yeah, exactly. And so things that come into play are things like testamentary trust in that instance, whereby it doesn't need to form the entire part of your estate, but that portion that's going to go to that particular person where you don't want them to receive a lump sum, you can choose for those assets to be put into a trust, and then the income distributions will be paid out to that person, so that you're still helping them out in the sense that they're receiving a regular payment in order to be able to meet their lifestyle or whatever the intention is. However, they're also not burdened with needing to manage those funds if they don't have the capacity, or you don't think they're going to be able to do so on their own.
Yeah, and that's probably the most used scenario that I can think of, being a testamentary trust, to be able to provide some structure and some oversight over the funds, especially if you've got, beneficiaries in that instance. And, if you can set it up correctly, I think it ticks the box. If you've got a child that has an issue, or, is a spendthrift or whatever, maybe you're better off, drip feeding them income to support their lifestyle rather than giving them access to, hundreds of thousands of dollars, because that will make things worse. So I really like the idea around testamentary trusts and shaping it like that. I guess the complexity is always trying to anticipate, what's going to happen tomorrow when you're here today.
Yeah.
Because things do change.
And that's, we're already sort of at the end of it. But
it'll be a common theme.
Review it, right? Like,
we're going to say that word about 10 times throughout this, but yeah, definitely review it.
Yeah, because we've seen it so many times, right? And then, so even when we're talking about, things like who you actually want to receive the money, it needs to be reviewed on a regular basis, because there's relationship breakdowns, whether that's in a relationship de facto or a marriage. But outside of even just that, there's relationships that break down, and trying to unwind it, either not just if something's happened and you've actually passed away and the wills come into play, but if you've lost the capacity in order to be able to make changes to your will as well. Yeah. So it is very important to review this on a periodical basis as well.
Yeah. Andrew, one of the big things that we get asked all of the time is around the taxation status of receiving inheritance, or if it's a parent planning their, estate planning and thinking what that looks like. What do we talk to people about from a taxation perspective? What does that look like? Because it's not just, hey, I've got money, here it is, and away you go. It's all net, it's all tax-free. In certain circumstances, there is some tax and some strategies that we deploy in order to fix that as well too.
Yeah, so look, there can be an element of tax, and one of the biggest ones, generally speaking, Australia doesn't have an inheritance tax. So if you leave an amount of money to someone, there's generally not a tax that gets paid by that person when they receive that money. However, one of the examples of where you may incur an element of tax is in through superannuation is probably the biggest one, and when someone is a non-tax dependent. Generally speaking, it's when your beneficiary, or the person that's going to receive the proceeds of your superannuation, is not your spouse.
Yep.
That's usually what it is, or not a dependent on you. So usually a child that's under the age of 18. So if your beneficiary is adult children, and all you've done is just make contributions to your super, either via salary sacrifice or via your normal employer contributions, your superannuation has a taxable status on it. Now, there's a consideration when you're looking at it and saying, okay, if I'm going to be giving, for instance, child 1 my superannuation, child 2 this particular asset, the value might not actually be what you think the value is, because the superannuation may incur an element of tax while the property may not. And so taking that into an account from an equalization perspective is important, but also thinking about, okay, again, get advice, right? But there is strategies that you can deploy, like a recontribution strategy, whereby you can change the status of your superannuation if you meet certain conditions, so that there isn't an element of tax that's paid when that proceed gets paid out to a non-dependent.
Yeah. And look, for us, I guess when we're sitting in front of a client, whenever the opportunity presents it, like the circumstances of the client is such, we always look at that recontribution strategy to be able to change the taxation element of the monies sitting inside superannuation, because, you're talking significant amounts of tax if it's received essentially by anybody who's not your spouse or not dependent on you. So if we can do that, we definitely will. But one of the things that that you touched on that I wanted to sort of double back on is estate equalisation. So essentially what that means is, in the simplest form, you don't own any cash assets. So you've just got your family home and an investment property, and you've got 2 kids in this hypothetical situation. You might say, yes, child A gets one property, child B gets the other one, and that's all good and well. But the truth is those properties are never going to be worth the same amount of money at that particular point in time. So if you want to keep it fair and equitable, and not even if you want to keep it fair and equitable, it's how is it then perceived and received when you're gone? Because if one property is worth, a couple of $100,000 more than the other one, it's not going to be fair in the eyes of the beneficiaries. So unless you've given that some thought and some consideration, how you equalise that out or how you deal with that, that becomes a really big challenge within itself. So there's a few mechanisms around that. It could be that, both properties get sold and then whatever's left gets split down the middle, or it could be that, we know that there's a difference. We're going to have, a life insurance policy that sits over the top to be able to inject some liquidity into it. The kids might turn around and say, okay, we're going to keep the properties, we're going to get them valued, and if there's any discrepancy, we're going to use the life insurance payout in order to equalise it and make sure that it's fair and equitable.
Yeah, and I've seen that deployed even when you've got, a situation where properties are of equivalent value today, because the property values can change over time. And so no 2 properties are ever going to grow at the exact same rate. So I've seen clients utilize a strategy like a insurance policy in order to be able to equalize the estate, even when property values are exactly the same, because they're just no property is ever going to move in the same direction at the same rate all of the time.
Yep, 100%. Andrew, life interests in properties for things like blended families and the like?
Yeah, look, there's some complexity, and it's not just blended families, but I think that's probably the easiest example of it. So let's say you've got a husband and a wife that have children together and they separate. Husband marries or wife marries and they are living in a family home with another partner, and the husband still wants the beneficiary of the home that he's living in to be his children with the first partner.
Mm-hmm.
Now, touch wood, husband passes away. You've now got his current spouse that needs to move out of the property because the children are the beneficiaries of the property, unless the children decide to say, no, that's fine, you can continue living in the property even though we own it. Creates its own sort of issues in tax and whatnot as well. But it creates a conundrum. So what you can do is have a life interest in the property, whereby husband says, okay, new spouse is not the beneficiary of the property. The beneficiary of the property is still my children. However, I would like a life interest in the property whereby she might have the right to live in the property until she eventually passes away, and then the children will receive the asset thereafter. And so basically you're allowing for someone to have an interest in the property and continue utilizing the benefits of the property until they pass away, and then only then does it get passed on to the adult children, which will then be the beneficiary of the estate.
So complexity, things change, get it reviewed, get advice, and keep doing that because things constantly change.
Yeah, absolutely.
Yep. Okay.
Absolutely.
What about beneficiaries and being able to protect funds from being contested?
Yeah.
This is probably the most complicated part of estate planning because I guess it's up to the discretion of the courts and every situation is absolutely different.
Yes, absolutely.
So how do we think about it? What does it look like?
There are some strategies that you can deploy to be able... Now, look, one is making sure that you're engaging with a professional when you're putting together something like a will and your estate plan, because that's going to increase the chances that, one, you're sound of mind, you're making a rational decision, that the will is not going to get contested. It doesn't mean that it won't get contested, but it increases the chances that that's not going to happen. But 2 is looking at assets that don't necessarily go through the will. So a will is contestable, but a beneficiary nomination is not. So when you're thinking about superannuation, for instance, when you're thinking about life insurance policies, when you're thinking about even things like investment bonds, whereby you can actually quarantine some money and have certainty that that money is going to go to your intended beneficiary because you're making a beneficiary nomination and those proceeds don't actually flow through the will. So they don't actually even form part of the will. The beneficiary nomination will determine where those monies go, and that is not contestable.
Yep. Yeah. So some complexity that sits around that.
There's complexity that sits around it, and again, the concept of reviewing it is so important in something like this because it's not contestable. So if things change and you don't want that to go to that particular person for a particular reason, if you haven't changed your beneficiary nomination, it's not contestable. There is no way that that can be changed after the fact, irrespective of what the circumstances are. And so making sure when you are making a beneficiary nomination that, okay, this is the beneficiary nomination today, but I need to review it and make sure that it still reflects my wishes in the future because
because things change.
Yeah, exactly right.
One of the things that I think is missed, and coming back to the start of the podcast and thinking about who do I leave my money to, right? Is the main question, but around things like guardianships for children that are still dependent on their parents. So it's something along the lines of, hey, if something happened to you and your spouse, who looks after the 2 kids that you've got? Okay, great, fantastic. Seems like a simple enough question, but in practical sense, what does that look like? Okay, let's unpack that a little bit. Okay, so Andrew, if you and I were in a relationship and you say, or we agree that your parents have full-time custody of our kids, they become the legal guardian. Fantastic, that's great, we both agree to that. But what about my side of the family? What rights do they have, if any, to still see our kids? So just trying to work through the practical elements of what that looks like is a challenge. And then to add a little bit more complexity, in that situation, if it was your parents, how do they then get money to help support our children in the event that we're no longer around? And then above and beyond that, how do they then raise the children with certain things in mind that maybe we wanted to give to our children, whether it be life experiences through travel, where it could be, certain education standards that we want to give them. It could be certain religious beliefs that we want to raise them with. A lot of complexity in it, and it's not as easy and straightforward as one would think, but often often overlooked and easy to miss.
Yeah, absolutely. Yeah, absolutely. And I think with all of this, and we've still got a little bit to go through, but one of the things that I've seen work incredibly well is people actually, maybe not necessarily showing, but potentially showing, but discussing their will and their estate plan with their beneficiaries and who's going to be impacted by it. And this is why I've done this, and actually talking through it and having an open and frank conversation, because all too often it's like, well, will's going to get read, what's going to happen? And everyone's kind of sitting around wondering when the conversation really could have been had while you're still alive, so that, one, you're mitigating the chances that it's likely the will be contested, but 2, you're actually explaining your rationale and decision while you're alive and while people are able to actually listen to why you've made a particular decision in one way, rather than try and piece the pieces of the puzzle together and build their own assumptions after the fact.
Yeah, it's an
emotional time.
I was going to say it's hard to get an understanding of what the deceased person wanted to do if they're no longer around. I mean, look, just on that one regarding children, not necessarily when they need guardianships because they're younger, but sort of backtracking a little bit with the blended families. But imagine if you've got 2 adult children that are the beneficiaries of your estate. One's in a stable marriage relationship and the other one's in a unstable marriage and relationship, and then all of a sudden both kids inherit 50% of your estate equally, then there's a probability if your child who's in an unstable relationship, if that relationship breaks down, does that mean that, the family money that they've received then becomes part of the asset pool for the family law case for the breakdown of the relationship?
Yeah.
So once again, thinking through what that looks like, and definitely needing professional advice on this, but thinking through what that could potentially look like. And that could change. By the time you do your will today, your child may not be in a relationship. Next time you do it get it reviewed in 3 to 5 years' time, could be a completely different story.
Yeah. And I have had a client that's actually been through this particular scenario. So it touches on the conversation of what we're talking about today, but isn't necessarily directly related. So if you've had a relationship breakdown with someone, so let's obviously not going to give any particular names, but a couple who was married for a number of years were together and they had separated. Now, they had been separated for a couple of years. They were living apart, had purchased their own properties, but were just dragging their feet in relation to divorce settlement and getting all of that stuff sorted. Not for any particular reason, and they were just dragging their feet with it. In the time that they were separated, the wife's father passed away. There was assets that were taken from that estate that were then passed to the wife. Now, for family law circumstances, that forms part of the asset pool because the asset pool is valued at the time of filing for divorce, not at the time of separation. So that fortunately, the husband in that scenario was quite rational, and even though he had access if he wanted to for all intents and purposes in family law, he said, no, that's your inheritance and I don't want a piece of it. But that may not always be the case. And so I think the learning from that is not only just looking at your own estate planning, but what's the impact of, inheritance in my own situation if something does happen. And so getting things really up to speed and getting your situation reflective of where it actually is today is so important, because dragging your feet, we were talking about literally almost $1 million in assets that could have been added to the asset pool if this person actually wanted to pursue it.
Yeah, perfect example. And I think that's probably, in terms of the way that he handled it, I'd say that may even be the exception rather than the rule.
Yeah.
But yeah, you're right. Imagine if he decided to go for it. that would be absolutely tragic. So yeah, interesting.
Powers of attorney and healthcare directives, Bill. So that's another important one.
So powers of attorney, healthcare directives, basically in the event that you can't make either financial or medical decisions on your behalf, because we think about estate planning, I guess, in black and white. Either I'm alive or I'm not, right? Whereas if you're in a position where you're incapacitated for a period of time, or you can't make decisions because you've suffered dementia or whatever it may be, having these instructions as part of your estate planning about who will step in to make decisions on your behalf around a couple of these key areas is absolutely critical. And having that conversation with the person, making sure that, one, they're the right person, two, they're willing to take on the responsibilities, and three, they have a really clear understanding about how you would make a decision in certain scenarios is absolutely critical. And I think that's really overlooked from an estate planning perspective as well too. Ordinarily, if something were to happen, I guess by default it goes to a next of kin. In certain circumstances that may be okay, but you don't want to leave that stuff to chance.
Yeah, absolutely. And finding and picking someone that, if you're talking about, powers of attorney, one is someone who has the capacity to make the decision, but two is someone who would make the decision that you otherwise would have.
Correct.
So an example is, just because a brother might be, or a sister might be fantastic with money, you might want them to be the financial power of attorney, doesn't necessarily mean that you want them to be your power of attorney, because they might have extremely different concepts of money. They might want to, or their perception might be completely different to yours, despite the fact that they're able to manage it well. They might have a much higher risk tolerance, and you might not, necessarily want that. So you want someone that would make the decision that you otherwise would have made, and potentially talking to them and explaining what that actually entails is important. But I think it is important to note that it's not just the best person that I know that's good with money.
Yeah. Well, one step further, I mean, that's from a power of attorney perspective, but appointing an executor as well too of your estate. So essentially this person or people, because it doesn't necessarily, in both instances, around powers of attorney and your executors, it doesn't need to be just one person. You can have multiple people, but from an executor perspective, this is the person that will administer your estate and complete your estate.
Yeah.
So once again, making sure that person has capacity to be able to do that. They understand how it all works. They're prepared to accept the responsibility associated with that too. That's a critical decision as well, because it's not easy administering an estate, and the more complex that it is, the harder the job becomes as well too.
Yeah. So I think the takeaway with all of this, Billy, is get advice, seek an expert opinion, and review it regularly is definitely the key takeaway out of all.
And give it some thought about what you want to see happen in the event of X and Y and Z.
Yeah. Absolutely. Absolutely.
There you go. To our viewers and our listeners, thank you for that. I hope you got a whole heap out of today's episode. If you've got any questions or wanted to reach out to the team at 360 Financial, details are in the show notes. Don't forget to like and subscribe, and we'll catch you on the next one.
Thank you very much.
Thanks for listening today. If you have any questions on what we've talked about or would like to have a chat about your money journey, visit us at 360fs.com.au.
Just a reminder to our listeners that the information contained in this podcast is general in nature and is not intended as personal recommendations for the audience. Please consider whether the information suits your circumstances before acting on it. This information is provided by Billy Amaridis and Andrew Nicolou of 360 Financial Strategists Proprietary Limited, authorised representatives and credit representatives of AMP Financial Planning.